So I know we have, and this is a pleasant situation, we have a lot of people joining us who are not partners or members, and we even have some artists joining. So I just want to encourage those of you who are agents and are not members or agency owners, if you guys want to join the AMA and support us, we could certainly use that. And any production companies here, or we would love to have you as a partner if you're not already a partner. So please don't hesitate to get in touch with me or with Jen or anyone on the board that you might know. We're happy to talk about options, and it's been really amazing to see the growth and the amount of encouragement we've gotten from those of you who are members. So please consider. We're at like 84. Should we get started perhaps? So yes, I'm really happy to have everybody here. And we have with us Doug, who is our attorney and has drafted our terms and conditions, and Kelly Montes will give him a further introduction and then start a conversation with him. We also have Emily Pitts, who represents a lot of you as well.
Hi, everybody. Like Vanessa said, if you haven't had a chance to join the AMA, that gives you access to the terms and conditions that we're going to be going over today. So please consider becoming a member or partner. Doug Roy from Cyprus, his law firm, is actually a partner of the AMA as well. Thank you for that, Doug. He helped us to draft our terms and conditions template. Again, it's a template. We encourage everyone to, of course, use it as a resource and to customize it to best fit your needs. If you have any specific questions about it, Doug would be happy to answer, or Emily, because I know Emily actually represents a lot of the folks on this town hall today too. But Doug, maybe we can take a step back before we start talking about our terms and conditions, and just have you explain to us a little bit about what was Balenciaga's claim? What were they targeting North 6 for?
Yeah, thank you for having me talk to everybody. And what a crazy couple of weeks this has been for this story, and what a crazy story. So I know all of you are well versed in all of the details, but I do want to just kind of take that step back and revisit what actually happened, because it's such a bizarre confluence of events that really created the sort of perfect storm and created a lot of anxiety for everybody in the industry. But so it is worth kind of recepping. So just bear with me for a second. About a month ago, the whole controversy started when Balenciaga released a campaign that we'll call the Gifts campaign, that featured young kids holding these bags that looked like teddy bears that are wearing what appeared to be some sort of S&M bondage gear. And there were sort of wine glasses, other things that just sort of seemed a little bit icky. And as happened, there started to be some chatter on the internet about whether this was actually appropriate and what kind of taste level this was, and whether we should be featuring kids in these kinds of positions. And then what really took the controversy to the next level was a completely different campaign shot by a different photographer with a different prop stylist, and as far as I can tell, a completely different production team that was in an office setting. Didn't feature kids, but did have a regular corporate office, and one image with a handbag on a desk that was littered with paper, and a internet sleuth zoomed in and saw that one of the pieces of paper on the desk was an excerpt from a 2008 Supreme Court opinion that upheld the conviction of the defendant on child pornography charges. And the internet, in its ultimate wisdom, then drew a connection between those two campaigns, and the conspiracy theories started and were perpetuated on a lot of cable news shows that suggesting that maybe Balenciaga did this purposely, and they were sending some sort of subliminal messages that somehow condoned or endorsed child pornography and child trafficking. Um, Even though if you look at the Supreme Court opinion, it in no way condones or promotes child pornography. In fact, what it did was it actually upheld a conviction saying that you can um, arrest and convict a person for offering to sell pornography that he doesn't even actually have. So the fact that this was drawn into the controversy just kind of goes to show you that you don't have to have any intellectual consistency or any logic to create a big PR hassle. But in any event, then it was just a series, I think, of missteps from Balenciaga. Um, in this weird turn of events, they on one hand took responsibility for the creative over the gift campaign and with the children and the bondage teddy bears, and then on the other hand went in a completely different direction and filed suit against North Six, the production company and the prop stylist for the office campaign, which arguably is the less controversial of the two. What's important to note in this conversation was that lawsuit, or the allegations that were in the summons of it, didn't actually focus on the creative. They weren't accusing the production company and the prop stylist of infringing on anybody's rights or including in any creative that was offensive or immoral. It was actually something more specific having to do with the props. They insinuated that the prop stylist had lied or misrepresented about the nature of the props, had told the client that these were dummy props, fake documents, when in fact it turns out that at least some of them are real, or even potentially worse, going as far as kind of insinuating that there may have been some malevolence involved, and this could have been some purposeful action by the prop stylist to put some subliminal message or some damaging information to sort of sabotage the brand of the campaign. From a legal standpoint, it's a very thin claim, especially when there was nothing really inherently controversial or damaging about the Supreme Court, about that particular prop, the document, or the Supreme Court decision. It only became potentially problematic when it was viewed in the context of a completely separate campaign. And the fact that it was so legally thin leads me and a lot of others to believe that Balenciaga probably actually had no real intention of trying to pursue or win on this claim, but actually what this was just some very nearsighted decision to feel like they had to join in the righteous indignation of all the noise on the internet, and make some stand and show that somebody else was responsible and that Balenciaga was doing something about it. That decision, I think, turned out to also be a misstep, and they got a lot of blowback for that, and then, as you know, quickly retracted that claim.
Thanks for walking us through that. I think for all of us here today watching that, we had great empathy for what was happening to Nicholas and to North Six, and could easily put ourselves in their shoes. And I'm sure both Emily and Doug, you guys got a lot of emails and phone calls from us saying, are we protected against this? And we thought it was a good opportunity to not only go through the AMA terms and conditions so people know where we have protections for this type of claim, but also maybe talk about some of the other resources that we've developed that could be helpful in terms of making it clear who holds what liability. So, Emily, I'm actually going to kick it to you because I know that and maybe Jen, you can share where on our website and where in our terms, and we can talk a little bit about indemnification, mutual indemnification, and Emily, can you break that down for us a little bit and how that protects everyone?
Of course, sure. I think I was talking to, I think, Stacy recently this week. I mean, indemnification is always, you'll see it present in our terms and conditions through the AMA, and usually for all of the agencies, you'll have your own set of indemnification rules. They're all very, very similar. Most commonly, it's mutual indemnification in a client agreement. In this case, as I'm sure you know, with a lot of different jobs, there is both the terms and conditions provided by the artist, in this case, Nicolas Desjardins, with Streeters, who has terms and conditions, and then North Six, who provided their own agreement. I don't know, and I'm not privy to whether North Six subcontracted Nicolas or not, but definitely they had their own terms and conditions, and likely there was another agreement provided by Balenciaga. Now, the question is really what agreement controls. It's good to have in your terms and conditions language that dictates that our terms control if there's a conflict between the two. And then more importantly, something to look for in the client agreements is whether, first of all, it is mutual. Sometimes it's not as a default. It's good to have that. So indemnification in general, just so we all know what it is an agreement to compensate another party for something that comes up or an issue, and a covenant not to sue. So you agree to hold them harmless, not sue them, and to defend them, and essentially compensate the other party if you did anything wrong. So it's good and traditional and good faith for that to be mutual. Sometimes that's not the case and it needs to be adjusted accordingly. And I'd say 95% of the time, clients are okay with making that mutual. Another further way to kind of protect yourself, which I'm sure either North Six or Nicolas did, is to limit the scope of indemnification for when you would be needed to pay for anything for the other client or for the other party. And by doing that, you can make it, limit the reasons why you're indemnifying the other party. It would be ideal if negligence was not included at all. In this situation where there was something included, and as Doug said, on its face, on its own, it's not necessarily controversial. It's a US Supreme Court opinion that is very good and is upholding a conviction for child pornography. So on its own, it's fine. In the context of a completely different campaign, it was, in the eyes of the public, made to be very bad. So that being said, it could potentially be negligent, but there's a higher standard that Balenciaga or anybody would have to prove if we only provided indemnification for gross negligence, which is one word, and just add gross before negligence. And it's a very easy thing to keep in mind when you're reading these agreements to enhance the requirements that a party would need in order to even file a claim. So based on the limited paperwork we've seen from what was filed, Balenciaga had to claim that there was some malevolence and intentionality behind placing of the opinion. And that's likely, and I don't know this for sure because I haven't seen the agreement, but that's likely because the standard was gross negligence, which does require a kind of knowledge element, if that makes sense, and hopefully isn't too legal for what's required. And then the implication is, Nicolas or North Six intentionally placed that opinion there. And that's what they were claiming, likely knowing that that was not something that they could prove, but again, to enter the discourse in the PR sense.
And, Doug, you and I were talking about this earlier. In terms of indemnification, the lawsuit was going after, I think it was 25 million. Like, does this clause or section 15 in our T&Cs, does that limit it to the shoot that we're producing? I mean, can a client come back to us and claim lost revenue? Because I'm assuming that's how they got to that number.
Yeah, that's a very good point. That's addressed in a different concept, which is in the terms and conditions that's provision number 16. And it's a limitation of liability section. And you'll see this quite often. This is in the AMA's form, terms and conditions. You will also very likely see this in whatever master services agreement or SOW that you see from the client, that they'll have some language in it. One good, really important thing to point out is quite often you will see, if it is a client generated document, that it'll try to be a one-sided thing that'll protect a limitation of liability and limit the client's liability. You always want to try to make that mutual. And usually I haven't run into too many problems doing that. And what we look at, if you take a look at paragraph 16, it's really this first sentence that's going to be applicable. It says no party will be liable in connection with this agreement for any other party's lost revenue or profits, indirect, special, incidental, or consequential losses or exemplary or punitive damages. And what that does is really try to limit the damages to what are directly incurred because of the breaching party's fault, right? So if the deliverables were unusable and the client had to pay to produce a whole other shoot, if some of the artwork or some of the IP ended up not being cleared and we had to go back later on and get third-party clearances, if someone found that the didn't have that the images were defamatory or used somebody's name and likeness and they had to pay damages, those were all going to be direct damages that directly stem from some sort of problem in the production. What we're trying to exclude is something like Balenciaga, where they're saying, oh, we suffered $25 million in damages, and that came from the fact that nobody bought these bondage stuffies, or that our reputation suffered because we became a toxic brand, and because Kim Kardashian and all of these other sponsors and alliance partners dropped out. Well, that gets us really into the world of lost profits. This gets us really into the world of several degrees away from what the actual alleged problem was. And if you have language like this in chapter provision 16, that can go pretty far in getting those damages cut at a very early stage. And if you find yourself in a litigation, you could get that cut out before we have to get to trial, before you have to spend a lot in legal fees and be carrying around this potential exposure throughout the whole case. Making the amendment and making sure that the language is going to be mutual goes to a point that Emily raised that I think is a really good one and is worth repeating, which is this document that we all see on the screen is a great resource. I'm glad AMA has it out there. I helped AMA put it together, and it's something that I help a lot of my clients put together. In my view, I think that this is really has its best benefit as just a resource and almost like a glossary term for all of you to get familiar with what these provisions mean, because more likely than not, you will not be able to use this document as an enforceable document. And just because you attach it to your estimate, I would not just assume that that means that that's going to be the agreed upon document and that's going to be controlling. More likely than not, especially when you're getting into these clients, these big companies, they're going to have their own documents. They're going to have a master services agreement. They're going to have statements of work, and we have to assume those control. That means that you or your legal advisor or somebody has to go through that agreement looking for these concepts and these terms and finding in that agreement to make sure that it's going to work in your favor as much as you can. And if it is too one-sided, if it is unreasonable to have these conversations up front with your client contact and get those provisions amended. It's much easier to do in a statement of work than into a master service agreement, but it can be done. And this is a perfect example of that, where you'll quite often see this standard limitation of liability language, but only for the benefit of the client, and that needs to be amended to make sure that it's mutually beneficial.
Can I just ask a quick question here? If you're working with a client and you do not have a master services agreement and the only agreement you have is your estimate with these terms, does that then make it the document that is because it's the only one?
That certainly makes it stronger. You know, I would like in that case to have it have a signature block at the end of it and have the client sign on to it and have you sign on to it. And that certainly is going to help. That's also going to, I think, bring the issue to the fore a little bit. And it's going to call it out. So if the client thinks that they have some other set of documents that are going to be controlling, then they're going to not want to sign yours, which is fine. At least then everybody knows what we're dealing with.
Yeah, because I often hear, I can't change my MSA, but you can try to change it in the scope of work.
Yeah.
And then I
That-
assume other people, of course, I'd love to hear everyone's experience. A lot of times the scope of work, I am like, production is starting and I'm trying to slam through the scope of work and because I need my advance. So I'm negotiating from not the best position. Being totally honest, feel free to judge me. I'm judging myself right now for it. And so if the language is in the master services agreement, are these the main touch points to protect us in this instance to try to get within that scope of work? Is there anything, thank you, Carrie. Is there anywhere else within our T&Cs that we should try to work into the scope of work? Or a lot of times I'm trying to push to get it included in the purchase order, in the job description of the purchase order, anywhere else that covers us within these T&Cs?
Yeah, so that's, I think, very common. A lot of these clients, you know, spend a lot of money to have their internal legal team or outside lawyers prepare their master services agreement, and to get any sort of changes to that has to go through a big process through legal to get approval. So not likely to happen. Much more frequently, the people that you're dealing with on the creative director side or on the art buyer side are going to have some authority to execute a statement of work and to negotiate deal points. So that's really where you're going to have the most success. And honestly, the least amount of oversight on the client side to get substantive changes through, because it's only going to apply to that particular job and not to the whole relationship. Certainly, I think, but yes, so there are a handful of things, and when I'm doing this, going through it to help clients, there are a handful of things that I like to drop in the statement of work every single time. And Jen, if you don't mind, if we can just kind of scroll up to the top, we'll just kind of go through down the list. Number 3, certainly advance, right? Advances quite often are not going to be in your MSA, and those are going to be super important, especially you're going to need to have enough to take care of your crew right away and not have to wait 45, 60, 90 days or longer to be paid by the client. I think number 6, client approval, I think is super important. That's also something that quite often doesn't get addressed in MSA, or if it does, it usually says that the client has some period of time after they've received the deliverables to accept or reject them, and they can only accept by sort of written confirmation with you. That's not practical from a producer's perspective. You really want this client approval language in there somewhere that makes the client responsible for being on set while the shoot is taking place, so they can give you comments and give you approvals or request changes while the shoot's happening, when you actually have time to do something about it, because most of the time after the shoot's over, it's impossible to go back and change anything. And if they don't show up, or if they don't raise any concerns, the deliverables will be automatically deemed accepted. That gives you some cover, and that would have given some cover, something to point to in this Balenciaga dispute, especially with the point that I think a lot of people were worried about, which is with the teddy bear campaign, that, hey, we're not responsible for the creative. This is also a place where if you wanted to, you could actually kind of put that additional sentence in there that says, you know, client confirms that they're solely responsible for all of the creative decisions.
I would just add here to add onto that, because to speak to some clients that I have that specifically don't want a client on set, then in a way around that, then and I think which is helpful to have kind of anyways, is to the same point, make sure that there's language regarding acceptance of the work. But another way that you could say it is by stating that so long as the work has been delivered without any technical defects, in substantial conformance with the creative brief, then it will be deemed accepted. That also helps override the written acceptance requirement or the time that they have on the creative side to accept the work. I think depending on whether you own the work or not, you know, whether it's a work for hire agreement or not, there may be, you wouldn't want to run into an issue where there's, you know, an argument where they own joint copyright because of language that says that they're fully responsible for the creative aspect of the work. There's just, in the event that there's infringements of the work later, a client could come back and say, well, we own the work as well, and so we were able to use it however we want despite this usage paragraph because we were solely responsible for the creative. And that's like more deeper into creation of a copyright. That's not necessary here, but another way is I agree to make sure that there's language in the statement of work regarding acceptance of the work, but it can be in other ways besides just being present on set. It can also just be as long as it's been delivered in substantial conformance.
That's a great note. I know that this client approval, especially with the remote shoots
Right.
that we were doing during the pandemic, but even after that, has been really important for us in a handful of cases of, you know, maybe just having a junior art director on set, they're not looking at things as closely and being able to point back to this. This is something that we always put on that cover sheet. That's just a personal note. Something I'm curious about, and Doug or Emily, you could answer this. When the contract comes to the photo agency and we're hiring production, and then production is hiring the crew, where does responsibility lie there? How does that work? Because I guess what I'm trying to get at is for my other fellow artist agency owners, is it fair for us to be like, oh, okay, well, that's an issue for a production company, we don't have to worry about it. But if the contracts with the brands or with the agencies or with us, is that something that we then do need to be more aware of and think through?
Yes, absolutely. I think it's super important to have a very clear understanding of what everybody's roles are and who's going to be responsible for what. There's not going, the answer to that question is really going to depend upon how each job is structured. But the short answer to that is whoever holds the contract with the client is going to sit in the crosshairs if something goes wrong. So the client is going to look to, if the client has the engagement directly with the photographer's agency, let's take that example that you gave, they're expecting that entity, that agency is going to deliver a complete product, which are the deliverables, and that they're going to be responsible soup to nuts for its creation and production. Now, if they then, in that case, I think it's a good idea to try to also have the client deal directly and contract directly with the production company, and then the production company then takes on that responsibility. But then you can also then have indemnity obligations and protections that then go downstream. So the client engages the photo agency, and if anything happens, if the client runs into any problems, they're going to look and turn to the photo agency and say, your problem, you deal with it. Then the production agency should have a written contract with the photo agency should have a written contract with the production company that then tries to shift all of the responsibility for the production elements onto the production company. So then if the client has a problem, they look to the photo agency then look to the production company. Production company should have written agreements with all of its contractors and all of its department keys to make them stand up and be responsible for all of the production elements that fall within their department. So the indemnity can flow down that way, but it is still important to know that whoever it is who has the contract with the client is going to have to be prepared to stand up and take responsibility and sort of make sure and shepherd that everything downstream is happening the way it's supposed to.
And just in case people don't know, we do have a rep producer agreement template as one of the AMA resources for you to download and customize, but it's worthwhile to have those conversations. I know we represent stylists, and we have included in our terms and conditions that we put prop clearances as much as we can back on to clients. And I know, Doug, you've sort of felt like, well, that should be the responsibility of the production company, or are we clear just by having that within our contracts?
No, I look, I have no opinion about who should do it. My opinion is that that is a contract term that the parties need to discuss and agree upon and document. I think that if it's not articulated and documented, I think it is a reasonable assumption from the client. And I think most clients all the time will assume that, hey, I'm hiring an agency or a production company to come in and produce this shoot and bring props. I expect those props to be cleared. And so if the production company or the photo agency or the prop stylist, whoever doesn't want to take on that responsibility, that's fine. Everybody can agree and contract that the client will do it themselves, but I would very much want to see that clearly delineated in the statement of work. Same thing, that also goes with same thing with hiring talent. That goes with for wardrobe, if you're using product from the client rather than having a stylist pull wardrobe, all of that. I think your statement of work really needs to be very clear as to who is doing what and what you're going to be responsible for and what you're not going to be responsible for.
Yeah.
And then in the event that anything comes up and people show up with some production elements, props, product, wardrobe, whatever, that has third-party IP in it that has not already been cleared, and you don't have it in writing that it's cleared, then that should be raised in writing to the client. The client needs to be made aware of that right away in writing, and then you and the client have a decision to make. Do we take it out of the shot? Do we change the budget to go out and get clearance for it? Or do we think that, does the client feel comfortable enough that they're willing to risk it and think that there doesn't need to be clearance for it? They want to move forward.
The other option is for in post, right, to sort of change it substantially enough that it isn't an issue.
Right, that's true, right. Instead of just removing it from set, you could also clean it up in post.
Or in the situation that you said, if it comes up sort of last minute, where really there isn't time for anything and it's necessary. We've done that.
We've definitely done that. I just haven't put in writing that we're going to fix it in post, but it sounds
no,
like...
actually neither have I. It's just been sort of been a conversation at the moment. Be like, oh, or the client will come back to us after the fact and say, okay, actually change this color, or, you know, take this arm off the couch, whatever it might be.
Mm-hmm.
You have to be careful about that, just because quite often I see in these MSAs for sophisticated clients that it'll say, you know, you're guaranteeing that the stuff that you're going to provide in the deliverables is going to be all your own, or or if it contains third-party IP, it's going to be disclosed. And so if you don't disclose it and you assume like, oh, I'll just fix it and sneak it in post, that's probably going to be fine. But the client may say, I'm not paying the post costs for that.
Right. Or might assume that it's been cleared and want it to look the way it looks.
Or assume it's been cleared and not want it to be
Right.
altered because they don't like the way that looks. So even if you're going to fix it in post, I still think it's a good idea to get the client on board with that decision as early as you can.
I have a question. What happens if, as an agent, I don't have full-time producers, but I hire freelance producers, and they're organizing the whole production. I'm doing the main communication with the client. But they have their estimate in place, and I submit it to the client. So with all the legal agreements are all in order and they're responsible, but I'm receiving the money and then I transfer it to the producer. Like, would I be held liable because I'm receiving the money? Like, they should be receiving the money and then they pay me whatever, our agreement is.
Well, from a client's perspective, they're going to likely say, hey, look, our deal is with you. We entrusted you to control this job, and we are going to hold you responsible to make sure that it's done in the way that it's supposed to. If you have a contract claim against your producers to shift that liability downstream, Godspeed. But in terms of the relationship and the risk with the client, they're going to look to whoever they've contracted with.
Okay.
To make it right.
Jen, could you throw in the chat the link to our rep producer agreement? Because Jackie, and this is a document that could help you to put this in place with your producers. It's another.
I get a little nervous. I'm like, you better do a good job because.
Yeah. Then you can turn around and then you kind of sit in the position of the client, right? Now you're the client and the producers are producers to you.
That's true. Okay. Yeah.
Now, look, this is just based on my experience, how we sort of typically see things. You can always contract around to make whatever scenario you want. You can have a 3-party deal with a client and a photo agency and a production company where everybody gets on board and agrees to who's going to do what and how that liability and responsibility is going to be shared. And in that case, there could be, direct responsibility on the production company. It's just not that often, because most of the time what I've seen is the client just wants to deal with one entity, one party. That's what they feel like they're getting for the budget.
Right.
I'd love to talk a little bit about errors and omissions insurance, which, Doug, I know you and I have talked about. I'm still really confused. My experience has been when I reached out to my insurance broker, who is an insurance broker that many of us use in the industry, I was told that I was unable to get an E&O policy that would cover my roles and responsibilities as an agent or rep, which is still very confusing to me. Doug, could you maybe talk a little bit about maybe why I was told that and what we can do to get that protection, if that's...
Yes. So it's a super interesting topic, and I think really we could have a whole other town hall on it, and I'd love to have the insurance folks on it too, because it really is going to depend on the policy. E&O is something that in our world context typically tries to prevent against claims from third parties for IP related things, and you see that much more often in film and television and motion commercial context, where you've got so many more different people who are potential creators and could have IP interest in the deliverables. It's less often that you see it in still photography, because really you have the client who's going to own the creative. You're going to have the models who show up who need to have name and likeness releases, and you're going to have the photographer who everybody's going to see is actually going to show up and take the pictures and not crib them from the internet or something. And more often than not, you don't have a lot of clearance issues with respect to to props or wardrobe. So insurance is expensive when clients ask for it in terms of something that's going to be strictly a photo shoot. I try to push back on it just because I think it's prohibitively expensive, and you don't get a whole lot of benefit because it's just rare that it comes into play. But more to your point is, if they want to have the insurance, whose insurance is it? And that depends on how the policy is written, and it could be that what they're telling you is, hey, as a photo rep, it's really not, you're not really the insured. and if you get the insurance, it's not going to cover it's not going to cover the riskiest propositions, which is a mistake made by somebody who is not your employee, but a subcontractor, like a production company or a director or photographer who's not your employee, or a department key. Whether there's workarounds that can be made to have a photo agency be able to get E&O coverage that would protect those sort of downstream contractor partners, that's a better question for the folks that write the policies.
But in the instance where, I mean, so many of us are also running production these days too.
And as production becomes, as we see that wall that used to separate between motion and stills further deteriorate, and all jobs start to become more hybrid jobs, E&O is going to become a bigger issue. And I think if you've got some components that have a big motion element to it, you will have some clients that are going to insist on the E&O. A production company should not have problems getting an E&O policy.
And if you as an agency handle production, I'll just add to that because I'm about to sign off and say thank you very much for having me. Also, if you do handle production, I have clients that do have E&O insurance through Earl Eaton. I'm not sure if that's who you're talking about in our industry. He works with a lot of people in our field. He's a really fantastic insurance broker. He's very familiar with agencies and artists. And also, if your agency represents fine artists, insurance extends to fine art. So it can be a bit more nuanced, but maybe if you expand upon what you do and how it translates, it may be applicable. And also you can always get a COI. I know some clients do require E&O insurance, and then you can have that conversation with them about why it may not be applicable. And then, they can choose to pay for it themselves, or I think it's smart to have if you can get it, for sure. And thank you very much, Kelly, Vanessa, Doug, for having me. I have to get off, but I'm available for any questions. Thank you.
Thanks, Emily.
Thanks, Emily. I'm going to put Earl's information in the chat for everyone too, in case they reach out.
Quickly, so like with this prop stylist, a set designer, excuse me, if the shit really hit the fan and if he had an LLC, right, wouldn't he have been protected if they really came after him? If he was I know we were talking about that before. Am I correct? All artists should be an LLC to protect themselves if they decide to really go after the set designer, right?
All artists should have LLCs.
Yeah,
that would have protected. It would have protected his, or would have attempted, right, to protect his personal assets.
Exactly.
But they didn't they name him and his LLC? Are we talking about Nicholas?
Yeah,
But
that was my understanding.
Yeah.
Now, there are some ways to get around that in terms of, it's a little unclear, right? Because they actually didn't even file a complaint. As far as I can tell in this action, they just filed a summons, which is just kind of put the defendants on notice of a complaint that was going to be coming down the road, which is a bit of an unusual move, although I'm not a New York attorney. So we would have had to have seen later on what the actual claims and allegations are. It's always a good idea for the artists to have a corporation or an LLC to give them that level of protection for their personal assets, and that would typically apply and protect them for any types of contract claims or negligence claims. There was an insinuation in this thing against Desjardins that he had misrepresented and had lied about where he got those props and what he was doing. Fraud is something that you could pierce through and actually have a claim against an individual, not just the LLC for. So that may have been why you saw him. I really think what it really was Balenciaga at that point didn't necessarily have a clearly articulated legal claim and was doing this more just for a PR benefit rather than to really pursue legal remedies.
Yeah.
Doug, wouldn't like a lawyer that was defending you, wouldn't their first goal be to drop the charges against you personally and go more after the business as well when they try to make that argument for you?
If I was representing Desjardins, yes. I mean, I would always want to do whatever I can to try to protect their personal assets and have them, really just be the business. That's why, look, that's why I say you can having good legal terms and conditions, having a good lawyer, that's a very good, arrow in your quiver, whatever the expression is. But the other things that you really should have, and this applies for producers, for agents, and for all the artists, have some sort of limited liability entity, some sort of vehicle in place to protect your personal assets, and have good insurance.
No. And our artists should have insurance.
Yes, that applies at every level down the chain. Have good legal terms and good legal support, have good insurance support, and have an entity in the way to protect you.
I had someone text me because they're listening in on their phone, and it's a stylist agent, and her question is, what if, as a stylist agent, you often don't know what's been agreed to, and how does a stylist rep protect their talent when they're unaware of what a MSA or an SOW even says?
It's
Does that make
Go ahead.
sense?
well.
I was going to say, does that mean in terms of clearances, or do you know what the question pertains to? Like, what would be the
Just
relevant
in terms
question?
of like that the stylist is expected to get the clearances, or approvals on set, or any of those things. A lot of times that even coming down to like, oh, you agreed to 180 days final payment and nobody told me that.
Right.
Yeah.
Right. So it's that can be an issue. I think the way to really try to, if you're standing in the position of the stylist and the stylist agents, then it's just a reconfiguration of what the relationship is, right? Now, all of a sudden, the producer is your client. So forget for a second what the producer's relationship is and promises made to the end client. That's the producer's problem. You just want to focus on your relationship with for the stylist and the production company, and you want to paper it. You want to have a contract just like you would have an MSA, and it would be clear as to what your roles and responsibilities are. It would be clear as to who's going to provide what indemnities to the other party. It's going to be clear on when you expect payment and when payment's going to due and how payment's going to flow. This is, look, there are less complicated issues, I think, with stylists, right? Hair and makeup, I think, have sort of the easiest go about it, because in terms of these issues and clearances and IP and that sort of thing, and then wardrobe sort of next, because either what you're going to be doing is you're going to be working with an apparel company as a client and you're going to be using their product, or you're going to be out there shopping and what you're really trying to do is to avoid recognizable styles and logos. And you're going to be doing that from an IP perspective, but you're also going to be doing it from a creative perspective too, because if your client is Apple, you're not going to want to fill the image with, highly recognizable Balenciaga outfits. You know, you're going to want to keep the focus on the on the client and the client's product.
I have a quick question about how who gets the legal kind of responsibility in the event that the client, the advertising agency that's say advertising a fragrance, specifically sends you a brief with recognizable items, which they do all the time. They're like, we love this Balenciaga dress. And you're like, well, this is very recognizable. And they're like, well, find the same one or get the permission from Balenciaga, which is obviously impossible. So like, how would you, like, is there any legal, aside from saying like, you need to obtain the clearances, which is what we say all the time, is there anything else that you would recommend is added to terms and conditions in that specific instance?
Yes. So from a general perspective, with your terms and conditions, either in your document or their document, and with specifically with the indemnities, you want to get some indemnities from the client, right? And those indemnities, and this should be non-controversial, should include your incorporation into the deliverables of anything that's given to you by the client. And that could be the creative brief, and that could also be anything product, props, Balenciaga dresses, whatever it is that they, you know, insist on having or give to you, then they should be responsible for. If in the situation that you're saying, where they're saying, well, we want you to do it, and this is what you want us to get it, I think that that's just something that needs to be called out specifically in the SOW, right? Like, hey, look, we're going to try to get a clearance for this dress, and we got to put X amount of dollars into the budget to do it. Or we're going to try to find something substantially similar that doesn't need a clearance. Or you're going to have to be responsible for the clearance yourself. And I think that that's just really kind of keeping things, keeping communication as early as possible in writing as possible.
Yeah, I find that also in particular with European clients, they're the worst, and they want you to shoulder all the burden, even though their copyright laws are much more stringent than the American ones. So,
yep,
right. Maybe it's about having a sentence too, not even about the terms, but what's the right sentence to kick back to them to like scare them into agreeing, essentially. Right, like what makes them understand that they're asking for something that they shouldn't be asking for?
It goes into this indemnity language, right? So what it is it's saying like, hey, you've asked for this, you know, this isn't cleared. I'm telling you it's not cleared. If you choose to use it as part of the deliverables, then you're going to indemnify us and hold us harmless.
Right, okay.
Okay. That's good.
And they have to sign that.
Yes, preferably that's part of the SOW.
Can I ask a question regarding set designers, wardrobe stylists that are contracted for production companies?
Yes.
So a lot of times as producers, we sign off on deal memos for set designers and wardrobe stylists, usually with their terms that we've come to an agreement on. But with regard to IP and them also any mishandling of IP, should we be adding that into their deal memo or sending over our own contract with those terms?
An indemnity that's going to shift the responsibility and liability to them.
Yeah, basically saying, you know, any prop stylist, set designer, wardrobe stylist would be responsible for the client obligations of, you know, anything that was sent to them directly, that the onus does not fall to the production company, that any IP that the prop stylist or set designer provides is also cleared, that production is not liable for it, but that the production design department will be held liable for it.
Yes. So again, it's kind of a reshift in perspective, and all of a sudden, as the producer, you've shifted from being, you know, the producer who has to sort of bend to the client to now you turn around and you're the client, right? So you're going to then look to say a prop stylist, and you're going to say, hey, I'm going to give you, these are the services. You're going to go out and find props according to this creative brief. I'm going to pay you X. You're going to give me deliverables, which are all the products, and those deliverables are going to be unencumbered and free of any third-party claims. And you're going to rep and warrant that that's the case, and you're going to give me an indemnity for any breaches of your reps and warrants. So then, when there's an uncleared prop that shows up in the deliverable, in the image, and your client then turns to you and says, producer, you told me it was going to all be cleared. I've now got a third-party claim. You have to pick up the indemnity and defend it. You can say, okay, we'll take care of it. And then you turn to the production designer, prop stylist, and say, hey, look, you gave me an indemnity. You told me it was going to be cleared. You take care of it. But that's how it goes in theory. That's how it goes on paper. The other thing that you have to worry about is, how does it go in practice? Because the prop stylist's indemnity is only as good as their ability to actually stand up next to it and cover that loss or pay for that defense. They most likely, or I shouldn't say that, they may be a smaller operation even than your production company, and they may not be able to handle that. And if they can't, you still remain liable vis-a-vis the client. So that's where that goes back to what I said before, which is your terms or conditions are great, your insurance, but you also want insurance.
And we also want our artists to have insurance.
And you would also want the artist to have insurance.
And would there be, just adding on to that, what would be like the main difference there if, let's say, we're running one of these artists, wardrobe stylists, production designers, or even photographer directors through our payroll, as opposed to them having their own LLCs and corporate, and then we're running them and having them sign off as independent contractors? Is there a difference there for their protections if we're running them through payroll?
Yes, because if you're running them through payroll and they are your employees, that's even less protection from you, because then you can't shift the responsibility to them.
Yeah.
Right.
They are your employees, you are responsible for them. You can only shift the responsibility down if they're a separate entity and contractors.
Right.
But again, that doesn't change the fact that you're ultimately responsible to the client. Say you have that indemnity in place with an LLC, with your prop stylist's LLC, right? A claim comes up, there's a $1 million claim somehow. Client then turns to you and says, Carrie, deal with it. And then you turn to the prop stylist LLC to deal with it. And that LLC has folded. That prop stylist is no longer in the business. That prop stylist has gone bankrupt. You can't find that prop stylist. You don't have the ability to go to the client and say, they're gone. The client's going to say, too bad. It's still with you. So again, that's why you want to have insurance, as much insurance as possible, in connection with all of that. Now let's not get
so depressing.
Yeah, let's not get depressed, and let's not get scared of our shadow, because the reality is like, especially in still, like, this just doesn't happen that often. That's why E&O I try to push back on, because most of the times you don't need it, because it just doesn't happen all that often that props need special clearances, or wardrobe needs special clearances, or somebody makes an allegation that the photographer didn't actually take the picture.
Do we have an AMA, like, I don't know, standard, like what you should have in your liability insurance to be properly covered? Do we have that?
We have a webinar and that we did with Taylor and Taylor and Pat. I feel like we should have another insurance webinar this year.
Yeah.
And everybody was laughing at me on the board because I was so excited for the insurance webinar, but it's great to go back and listen to it. And he really breaks things down and one of the things we talk about if you're working with an ad agency is, they often want to give you their policy, but in order for that policy to become your policy, you have to request to be a named insured, which means your name goes into that upper left box. And then that policy fully covers you as if it were your own policy. But it's an excellent webinar to go back and I moderated it and I watched it myself 2 additional times. It's pretty important stuff to know.
It's depressing.
Are there any other questions that anyone would like brought to the conversation? No.
I think so. Just basically artists must have LLCs, and it's so hard. I mean, some of mine do, and some of just, my accountant said it's really not necessary. I'm like, well, your accountant doesn't know what he's talking about. So maybe you should get another one, like you need liability. You need to be an LLC. Like sometimes I'm almost like gonna think like, you know what, I'm not gonna rep you anymore if you don't have it. Does anyone do that? Where it's like mandatory, you have to have an LLC?
We put it in our contract, and also we did work with our artists. It took 2 years to get everyone compliant with incorporating, with having their own general liability certificate and their own workers' comp certificate. And we have a lot of conversations with clients as to why, we need to be named, and we need insurance and compliance. So but it was a uphill struggle. And now it's baked into our contract with all new artists that they cannot go on the website until they have everything covered.
Okay.
And renewed. They have to put it on auto renewal, and our in-house coordinator has a whole timetable of when their insurances expire, and reaches out to them and say, if your credit card changed, update it.
Wow.
We're looking for that insurance cert at the end of this month, and we're looking for us to be, named on it. So yeah. And also, to Kelly's point, it would be great to have another insurance webinar, because there's new things that I didn't know about, like cyber insurance, and that is a really interesting piece of coverage that could be helpful down the road. Yeah.
I think it's just important for us to all know that if the money is flowing through us, we have liability. We can't just assume like, oh, well, the producer is going to take care of it. And that's another reason to have that rep and producer agreement. But like Doug said, that's how it works on paper. So making sure that you're covered as well.
And it's in our estimates. I mean, we bill it back for every artist. So they're not out of pocket for that insurance. It's not, it's coming back to them on,
What do you mean? What do you mean by that, Pat?
Charge clients for insurance.
Yeah.
A line for insurance.
Okay.
But it's really to the benefit of the artist to be insured. It's not something we're trying to pass off. It's for their benefit.
Yeah.
And for them to be their own entities and incorporated or an LLC.
And my artist liability insurance is just the whole LLC thing. Some have it and some don't. Okay.
Pat, did you say that your agency, the agency needs to be listed as on the artist's insurance?
Yes.
Okay.
On the if you go into the recorded webinars and watch the insurance webinar, I think they go over it really well. But yes, you should be named, as Kelly said, in the upper left. It's not good enough just to have a cert sent your way. You have to be listed. Your company has to be listed.
But in this instance, you'd be named as an additional insured. What
Yeah.
Kelly was referring to
Yeah,
is when it's
that's correct.
agency insurance, the agency gets named you as a named insured. They're two very different things.
Okay, thanks, Denise. Yes, additional insurance. Yeah.
When it's coming from your artist, you're an additional insured.
That's
When it's
right.
coming from the
Correct, because
agency, you're a
when
name.
you're in a,
Your name.
when you're an additional insured, it protects you from the other party's actions. So if the artist were to do something wrong and you were gonna get named in that suit, you were named as an additional insured on his policy and it would address you for his actions. In the agency situation, you want to be named as a named insured because you want to be protected for your actions, because your insurance policy is not addressing that job. The agency wants to provide it for you. So you have to be named insured things that you do wrong.
Got it. Thank you.
Sure.
Doug, I had one question. So, what we often try to do, I mean, the majority of the time that this comes up, we always try and push off the production. So I always just say form is not a production company. You know, we look to the client to provide, or the producer that is getting hired by the client to provide the insurance and pay all of the crew, pay all of the set designers, like stylists, talent, all of that. So in that case, do my artists, and often if we're even bringing on a producer to a project, I have the producer commission directly with the client for the production. And then we submit a separate estimate just for fees, or like fees and retouching and usage, and for our artists. So that's a way to keep it kind of more clean. But then do the artists also still need to have workers' comp in that instance? No, right? Because they're not touching any of that in terms of paying crew.
So, okay, so let's go. First of all, I like that approach very much. If you if your role is going to be strictly acting as a rep for your photographer and to try to get that photographer the job, and then to facilitate the production, and you don't want to take on any sort of risk or liability, have the production company contract directly with the client. That should avoid a lot of that risk for your photographer and for your agency.
And also, just so everyone knows, the way that we do that is I facilitate a lot of the discussions at the start, and I'm the one that is passing along the estimate, the production estimate, to the client. But as soon as it's approved, the client is signing off on that producer's estimate, and then they get connected. And then all of the discussions after that point around production are handled separately, or I'm on copy.
Right.
So then there would be a separate agreement between the client for just the photography services. And ideally too, if you're executing that agreement, ideally it would not be an agreement between client and your agency. It would be an agreement between client and your artist, because it's your artist that's actually getting hired and doing the work, and you're just signing on the artist's behalf and negotiating on the artist's behalf.
I even have the artist sign it. So I have the client make it out to the artist. In some cases, they want us both to sign, and I will do that, but I try to have the artist sign it as much as possible.
You have the artist sign what? Sorry.
Sign the agreement. So the agreement between the client is between the client and the artist, and not the client and form.
Does the photographer then receive the payment and then pay you?
No, actually, a lot of the time they'll pay the company, but they'll still have the artist sign the agreement. In some cases, though, that does get tricky, Kelly, and then I'll also sign, but I have both the artist and us sign.
And that should be fine. That should just be something that's in the agreement, right? Because the artist in the agreement can sign away and direct the client to send payment care of the agency.
But does that in fact limit the workers' comp need?
Well, so to go to your workers' comp question, it's going to then depend upon how the photographer wants to operate. So if the photographer services is just going to be that single individual, and the rest of the photographer's crew is going to be hired by the production company and paid by the production company, then it should be the production company's burden to provide workers' comp coverage for all of that crew.
Yeah.
Some photographers like to keep their crew close to them and like to pay their own crew because they have that control. They have people they work with all the time. They want to make sure that they're getting paid how and when they want. If
Mhm.
they're going to take on that responsibility and run that crew through their payroll, then they need to have workers' comp to cover those
Yeah.
crew members. If it's just the photographer, then the photographer should have they can have workers' comp through their company to cover if they get hurt on set, or they can have their own individual healthcare, medical insurance.
Okay, thank you.
So the artist agency doesn't really need workers' comp if you're not paying any crew, right?
Well, if you have your own employees, so if the agency has multiple reps working for the agency.
No, I'm a single person, so I just,
Right.
so I don't really need workers' comp because I don't pay any of the crew. And my photographers are independent contractors. Right?
Correct. So as long as you have no employees, you
Yeah.
are the only employee, then you're fine. You can have it. There's a way to get away around having the workers' comp requirement because you have your own. You're going to be responsible for yourself.
Okay, just liability insurance, okay. Okay.
But the thing to be aware of, if you are in the position of trying to package these deals and kind of facilitate and make sure that the production is moving forward, just the thing to keep in mind is that everyone who's going to be on set as an employee needs to be covered by someone's workers' comp, right? And that typically is going to be the producer, or it's going to be their the head of their department.
Right, okay.
So get it in writing, have insurance. Got it.
I will just say as the production company that we require, if we pay anybody, that they have to have, that's not on an invoice, they have to have workman's comp. If they're an employee of ours and we run them through payroll, then we cover that workman's comp. But they have to prove workman's comp if they invoice us.
Right.
Yeah.
So fun.
Yeah, it's really a lot of fun. Oh my God.
Right, well, we will do another insurance one. This definitely
Yeah.
proves the need.
Doug,
We'll do
thank
that
you
later this
so
year.
much.
Yeah, no, my pleasure. I always like to come and talk about this stuff. So it's fun to see all your faces and to listen to your questions. And I am available. AMA has my contact information. If anybody has any other questions, feel free to reach out to me.
Thank you.
Thank you, Doug. Thank you.
And thank you everyone for joining. We
say one
will
thing?
see. Yeah.
I mean, for future, I would love for us to have again, a in-depth social media discussion, like usages, breaking it all down. What does everybody ask?
You know, we actually just added to the website an area for suggestions. So at the bottom of the
Okay, so
homepage, we really would love these kinds of suggestions because the more we hear from you, the more we know we're giving you guys what you need. So put in any ideas, any questions. Can also always go to Jen or to me, but that's a great idea. And usage is always a topic that I think people want to talk about. So we will add it.
Yeah.
Thank you.
And please, if you're not a member and you're not a partner, consider, it's important to have our community behind us, not only showing up here on these Zooms, but monetarily so that we can continue to create more resources for all of us. So please consider joining if you haven't.
And just as to clarify, agents can be members, producers can be partners.
Yeah, it's a great gift to give yourself this holiday season.
Shake Productions is going to join today.
Fabulous.
Fantastic. Thank you. Amazing.
Appreciate
well,
it.
thank you all.
Thank
And,
you.
we will see you soon. Thanks for being here.
Thanks, Doug.
Thanks, everybody.
Thank you.
Bye.